I've thought of this concept for many years and I pitched it to the senior leadership over at LAPFCU and they have approved it. So I want to say thank you again for this opportunity to present this topic. There are two parts to my presentation generally. It's estate planning as a general concept, but more importantly, it's inheriting 101. So it's really meant, the target audience is two people. For the owners themselves, the parents themselves, I'd like you to be educated about how estate planning works, but more importantly, also the children. Everything that I could give to you in 7 bullet points about how to inherit appropriately, how to inherit successfully, and how to inherit efficiently. And so that's really what the background and history of this presentation is. So let me start with bullet number 1, which is plan for incapacity. And really what I mean by that is most people think that they live for 86 years, for example, and then the next day they just pass away. And that is likely the case many, many years ago when the science, when the technology, when the therapy was not where it is today. I was in Orlando last week and there was discussion amongst the presenters that they can prove that the person who will live till 140 is standing amongst us. And that's because there are a lot of advances in the science of longevity. And so bullet point number 1, plan for incapacity. What I mean is you need to think about a time in your life when several things happen. Number 1, you are physically incapacitated. What does that mean? You can't go to the doctor. You can't go to the bank. You can't go grocery shopping. Who are you going to rely on? What resources are you going to have? Who's going to make critical decisions for you? Not just physical incapacity, but mental incapacity. And what we're really talking about is our healthcare decisions, financial decisions, and we're really trying to avoid a court supervised conservatorship. So some of the documents that you'll need to assist you during this period is certain powers of attorney. We have a durable power of attorney. We have a springing power of attorney. These are documents that you need to sign and you designate other people to make decisions for you, whether it's finances or healthcare. What's the difference between the durable and springing? The durable is one where it survives incapacity. The springing is the kind where the person makes decisions until you can't. So, for example, if you are no longer mentally incapacitated, there will be a provision that says someone else will make decisions for you. The durable, other people can make decisions for you even while you have capacity. So it's a little confusing. The kind that we use in our office is the durable because, in my humble opinion, you need the document to work sooner rather than later. The issue that I have with the springing is that in order for the person to make decisions, you need to prove that you're actually incapacitated. And proving incapacity, although it seems straightforward and simple, is very difficult. It's very difficult, realistically speaking, for a doctor to determine that you're incapacitated, number one, but number two, for a doctor to reduce that into a written instrument. So that's power of attorney generally. The living wills or the advanced healthcare directive are documents where you allow someone to make decisions for your healthcare. Now, let me tell you, the attorneys are the worst at this because what we do is we create documents that mean several things, but they're all the same. So, for example, in the East Coast, a living will. In the West Coast, we call it the Advanced Healthcare Directive. At the end of the day, it's a durable power of attorney for healthcare. It's a durable power of attorney for healthcare. Number 2, avoid the probate court. Now, um, perhaps you guys have heard of this before, but essentially, A vast majority of people end up in the probate court, and the reason why they end up in the probate court is because they don't have the proper documents. And so the probate court is responsible for several things, but the reason why it is notorious is because it is the actual court that transfers assets to the next generation if you didn't do that effectively and efficiently. But let me explain, and I have this video that you can see. It's very expensive, it takes a long time, and it is purely public. It is public. Now, just to be clear, if you have assets below a certain threshold, you will avoid probate. So if you have real property that is less than 61,500, it won't go to probate, which is a funny thing in California because I'm not aware of, generally speaking, especially LA County, that there is such a thing as real property worth $61,500. So that's a trick question, so to speak. The other category is everything else, including financial assets. So if you have less than 184,500, you won't go through formal probate code. So that's why I have simplified probate process for those people who have assets, real property lower than those thresholds. Again, for real property, it's 61,500. For all other property, including financial property, it's 184,500. So this video here goes over how probate works. Let's see if I can get this to work. There it goes. Okay. So the cost of probate is about 5 to 10% on average. And I'm going to use the example of a home, fair market value $1 million. Even if there is a mortgage worth $600,000, they will take $1 million times the 5 to 10%, which is $100,000. Very expensive. Now, in terms of the probate timeline, all across California, north to south, it usually takes 1 to 2 years. But of course, we have large counties. A perfect example is the one where we're mostly in, which is Los Angeles County. That is a notorious county. Too many people for its own good, and it is not uncommon that a probate going through court there, it will take 3 years, 4 years, or 5 years. Again, it's because of the volume of the people there. Now, again, what probate is, it's a court supervised process where if you don't have proper legal documents when you pass away or when you get sick, that is the court that will administer your estate. It's expensive, it takes a long time, and it is public. So that's why number 2, in terms of inheriting properly, I recommend that you completely avoid the probate court. So then what do you do? Number 3, you create an estate plan, and in any good estate plan, you have several important documents. The most important, number 1, is the revocable living trust. Revocable living trust. Now, there are these ancillary documents. I'll go over the difference between a will and a trust. Now, this pour-over will is a special will. It's not any other will. It is the kind of will that goes in tandem when you have a revocable living trust. And it basically supports it. It's the event that for whatever reason you do not have an asset inside or owned by your trust, the pour-over will transfer that thereafter into the trust. So again, it's a very special will. It's not any other will, and it works in tandem with the revocable living trust. The other important documents, we went over some of them already, the power of attorney for finances, the healthcare power of attorney, which is essentially allowing someone to make healthcare decisions for you if you can't. We also have the HIPAA waiver, which is healthcare privacy. You're saying, for example, if your wife and your eldest son can make decisions for you, you're also saying through that document that they can view your otherwise private medical information. So this word estate, I think, is why a lot of people get confused. And the natural disposition of people is to think, well, I don't have an estate. I'm not that wealthy. I don't have, millions or billions of dollars. It doesn't apply to me. And essentially, an estate is basically your assets, and that can mean modest assets. Again, you saw my earlier slide, personal property, financial assets included north of $184,000. Guess what? A lot of people have that. They're not necessarily millionaires, for example. And clearly, with respect to the real estate threshold, that's merely $61,000. I am going to guess those of you that have real properties, even if it's not completely paid, that you will fall under this category. Included in this state are physical assets, so cars, artwork, memorabilia, heirlooms, for example. That is very important. I've been involved in cases where it's a beautiful estate plan, all of the assets are great, and the kids end up fighting for grandmother's tea set because it is a very important document, very important piece of property that if you don't have specific instructions, the children can end up fighting. So essentially, the planning part of the estate planning is the process where you transfer your assets to the beneficiary. So I'll explain that through a slide, how that actually works. All right, so this is a top 10 question, which is, Ed, do I need a will? Do I need a trust? A lot of people think that it's a will. What's the difference? And again, it is based on the value of your assets. So for example, if you don't own real property, or if your real property is worth 61,500, I want to come over and have dinner at your house to see what the 61,500 real property is because I can't believe it. And or personal property under 184, then a will is just fine. If you use a will and you have these assets, it will go to probate. All right, so I say if you're banking just on a will, you are going to probate. Again, probate is expensive, it takes a long time, and it is public. If you have minor children, for example, that is an example where you need to have a very special plan. You need provisions that will not only designate who's taking care of your children, number one, but number two, where are these assets going to be safeguarded? Who's going to be in charge, right? And so again, the trust avoids probate. And like I said previously, a will is included in a trust, and that is a very specific kind of pour over will. So the question is, if you have these assets, greater than 61,500, greater than 184,500, you need a trust. If you don't have these assets, then a will just be fine because it will not end up in probate court. I wanted to go over basically what is the difference between a will and a trust. Essentially, they have very similar things. They talk about who's in charge if you pass away. That's called a executor or an administrator. The will has provisions on who will inherit. But in my opinion, the basic difference between a will and a trust is whether it's going to probate or whether it's avoiding probate. And so in a trust, if it's done correctly, you will avoid probate. So essentially, a trust is an agreement between three parties, an owner, a manager, and a beneficiary. And when you set up your trust, you're actually all three of these individuals. That's a very confusing thing for a lot of people. You're the owner because you own the home, for example. You're also the manager because you get to decide when to refinance and when to rent or when to sell. And finally, you're also the beneficiary because if you sell the house, you can benefit from the proceeds of the sale. Now, in the estate plan, while you are the trustee, if you subsequently become sick, you've already determined, for example, that your adult son will serve as the manager because you're still alive and you will continue to be the beneficiary. However, once you pass away, you've already decided through your estate plan who's in charge and who will inherit from your estate. When this happens, everything is in place and those individuals will come forward to manage your estate plan. All right, so it's a self-contained document where you designate today who's in charge in the future. So for example, if you're sick, who's in charge? And again, because you're sick, you're still alive, you remain the beneficiary. However, when you pass away, when you're no longer here, you've already determined, because you didn't use it all, who will then share in your estate, the beneficiaries. For example, if you have one son, then your son gets it 100%. If you have four children, you can say that 25% apiece. Right, so this slide goes over the parties. Again, the theme is some of them mean the same thing. Manager means a trustee, but essentially you are the grantor settler. You're the owner because you create it. The trustee is the manager. Successor trustee is the person after you that will take charge that you designate. They must come forward because you are either sick or you've passed away. And then finally, the beneficiaries. Remember, if you're alive, even if you are incapacitated, you remain the beneficiary till the last day. When you pass away, obviously you're no longer here to enjoy. You've already determined who are the future beneficiaries. So a lot of people get scared. They say, Ed, I don't want to set up this trust. If I set up this trust, my kids are going to kick me out because I no longer own the property once I put the house in the trust. That is a big misconception. You remain the beneficiary until the very last day. I tell my clients that if you happen to live forever and you use all of your assets and you have 4 children and $4 are left, each of your children will get $1 apiece because you've managed to use it all right? So benefits of a living trust, it's revocable. You can change it so long as you're still alive, so long as you have capacity. If it's done correctly, meaning you've set it up properly, you've funded it appropriately, it avoids probate, backup name to step in at incapacity. So that's one big thing that I am a huge fan of is that the trust has provisions when you become incapacitated. I'm going to already predict that. Let's see how many people are here because I always like that. Let's see, 1 second. So I've got 137 people. I was banking on 150 based on my metrics here. So I'm about spot on. So thank you to the 137 of you that are spending your Wednesday afternoon. I know that this is a tough sell, but I hope Christopher and I are going to do this justice and you walk away smarter, motivated, and enlightened. So, going on with the benefits, you keep control of the assets. And again, we're going to talk about protecting your heirs as well. All right, so again, I'd say the name of the game is to avoid probate, right? But also, so this for those of you that are the children and you're listening to me with the focus of how do I inherit efficiently, there are some wonderful things that we can do in the trust for you for the future. And so, for example, again, this is in the spirit of love. This is in the spirit of protection. And this is in the spirit of preservation, right? Mom and dad, your parents, your loved ones, whoever is going to include you as a beneficiary, your godmother, your godfather, your godparents, for example, they don't have kids and they're going to give their whole estate to you. Well, guess what? They want to give it to you in a protected fashion. So they don't want other people to steal it from you. So if you so happen to be a spendthrift, or if you so happen to have, um, vices, or you're addicted to something, or you gamble, right? And you know it and you're being honest, the trust can be set up in a way that it only goes to you, not your creditors, not the people that sue you, for example. And so that is why I tell my clients when they meet me, I need you to come to the table and tell me what's on your mind. Tell me what you want to protect. Tell me who you're afraid of, and tell me what the overall agenda is, because it is only through that transparency that I'm able to craft a trust that can really serve its purpose, which is at the end of the day to protect your loved ones, right? So if you have minor children, right, we avoided probate, so that's great, but do we want to give the money when they're 18? Do we want to give the money when they're 21? They're a senior, or they're on their last year of college, and then they get this windfall from you, and then they say, "Hey, Monday, I can go to the bank and withdraw the money, or I can continue on my last year of school." I personally feel that children should not inherit until they're between 25 and 35 years old, because research shows that that is where maturity usually happens. And so in these trusts, we can actually set up a trust so that it is for them. The benefits are there to support them in all of the reasons why they need financial support, but they don't actually have manipulation and control of the assets until a later time. So our office can work with you to determine who can safeguard these assets, whether it's their uncle, whether it is their godparents, or sometimes you need an institution like a professional or a bank to come in and professionally manage the assets if we need heavy guns. Person with special needs, I include this because there are certain government benefits that you need to qualify for. For example, if you have more than $2,000, you can get disqualified for certain government benefits to support special needs individuals. And if you are not careful and you include your beneficiary, your child or your loved one who has a special need and they get more than 2000, they can be disqualified, but also they can be requested to respectfully pay back government aid because now they've fallen into money. A special needs trust is a fantastic tool where you can give them an unlimited amount and yet they can still simultaneously be supported by certain government aid, and then the trust that you set up will also supplement. So a perfect example that I give is if your special needs individual needs a wheelchair, and the type that the government will provide is the manual one that you propel with your hands, but we wanted the one that's electric or motorized. What we do there is we receive whatever the government gives, and then we supplement or upgrade with the special needs trust the amount, the threshold, the amount that we can purchase the motorized wheelchair. Certain government aids doesn't cover certain dental procedures. Let's say the special needs individual wants to travel to Orlando to visit her cousins. Uh, Basically, the trust supports or supplements the individual with special needs for things that the government doesn't cover. It's a wonderful tool. Those of you on this call that have special needs individuals, I encourage you to pursue this. Asset protection, I've touched on it with respect to spendthrift beneficiaries. I'd say top 10 question is this. Mother comes to me and says, my son is wonderful. I love him, but I don't like who he married. And this is a true life story. I've been practicing for more than 15 years. And so they come to me and they say, hey, we're going to, we've worked so hard. And the last thing we want is for our estate to go to our daughter-in-law that we don't like because we never thought that our son should have married her. And this can go both ways. Mom can come and say, my daughter, and she married this person with, I just call him the person with the tattoos because he exemplifies the son-in-law from hell, so to speak. They come to me, so what we can do there is we can set up a trust. So when the money goes to your child, God forbid they end up in a divorce, it is asset protected. It's asset protected from the divorcing spouse. It's asset protected from creditors, from judgments, from liens, and it's also asset protected against bankruptcy up to a certain point. I want to spend a little bit of time on blended families because I want to be honest. This is the new thing. It used to be that you meet with a couple and it's that traditional couple where mom and dad have the same kids. And that's very traditional, so to speak. And I'd say that's not so common. I'd say the modern blended family is very common. And so I have a video here that I want to go over. And so having a blended family where each spouse was previously married or was in a relationship that produced at least one child introduces interesting factors to consider. For example, I represent clients who have been married their third time, and in each marriage, they produce at least one child. Can you imagine? For example, in the Brady bunch, Mr. Brady had three sons from a separate marriage, and Mrs. Brady had three daughters from a separate marriage. If one spouse passes away and the surviving spouse inherits all of the assets, this definitely introduces a level of complexity for each spouse to consider if one of them were to pass away. So in a worst case scenario, if Mr. Brady were to pass away before Mrs. Brady, and we assume Mrs. Brady inherited the entire estate, she could intentionally or unintentionally disinherit Mr. Brady's three sons, and they could get nothing. So for those of you on this call, Those of you, oh, look, it's 142. I just need 8 people. So if you guys can call 8 of your friends, I will have accomplished my goal. So for those of you that are in a blended family situation, you definitely need an estate plan. You definitely need an estate plan because here in California, we are a de facto community property state. And what that means is without an agreement, prenuptial or postnuptial, California loves to give your assets to your spouse, right? And that's generally a good thing, right? But if you're in a blended situation, um, let's say you're Mr. Brady and you pass away and Mrs. Brady survives you, you give everything to her. Well, guess what? She is not the biological parent of your 3 sons. And although she might care for them, although she might love them, um, at the end of the day, she is not their biological mother, and she can intentionally or unintentionally disinherit them. So, what we do in this case is we have provisions that say if Mr. Brady passes and Mrs. Brady survives, we will recommend that certain assets go to the 3 children, 3 boys, right? Because what's weird is if the 3 boys have to wait for their stepmother to pass away, that is a strange situation. Mrs. Brady is going to feel, she's going to have to sleep with one eye because who knows if Bobby might come over and take her out because if she passes, then he inherits, right? I wanted to point out one of the things that is very special about my practice, and that is working alongside a certified financial planner, a financial advisor like Christopher Ellis. And Christopher and I have been working collegially for many years, more than 5 years. And this is the case where, I am of the opinion that estate planning is a part of the overall financial planning because this is a case where I, along with Chris, working as a team cohesively and collegially, work with you to figure out solutions, right? So that we can make everyone happy. Because one of the things that I see without sound advice from a financial planner like Chris is that you will just take certain assets without thought and say, okay, we'll give half of it to the boys. I'm a big uh, I do not promote that, for example, the house be divided because then that puts Mrs. Brady in a very difficult position. All of a sudden, she can be homeless because she'll have to sell or give 50% of the equity to these boys. And so I like working with Chris because he has the financial wherewithal, the background, the experience to suggest certain assets, for example, like life insurance, which, in my humble opinion, is a perfect asset to give to the boys. God forbid, Mr. Brady passes away. So I'll have Chris talk about it in detail more. All right. So it is 6:30, and I wanted to go over the Q&A portion. So I'm going to go over all of this. Again, we'll have a Q&A portion. I also wanted to tell you of our commitment to making sure that we answer all of your questions. There's a way to contact our office, to send an email. We have a QR code, so we will make sure everyone is nice and happy. Okay, so number 4, properly fund your trust. This is one of my pet peeves when I inherit a case. For example, you've set up a trust many years ago and you come to my office. I'll review the trust. Most of these trusts are not funded. And what I mean by funded is assets need to be inside of that treasure chest. So what are example of some assets? Real property, checking and savings account, and life insurance, right? The real property needs to be held in the name of the trust, recorded in the county recorder. The savings and checking accounts, they need to be registered in the name of the trust. That means you need to go to the bank, you need to go to the credit union, sit down with the banker and re-register the name of the account in the name of your trust. Life insurance, if you're single, you list the trust as primary beneficiary. You let the trust come into you let the life insurance death benefit come into the trust, and then it gets distributed nice and in an organized fashion. If you're married, you have 2 options. Uh, Spouse is primary, and then the trust as secondary beneficiary. If you trust your spouse, if you're in a Brady Bunch situation, you don't do that. You list the trust as primary beneficiary, and it will come in, and then the death benefit will be given to the boys if that's how we set that up. All right. Number 5, update the estate plan as needed. Uh, that's a top 10 question. Ed, I've set up a trust. When do I need to update it? I recommend that you look at it every year to see if everything is good, right? And then you meet with your attorney every 3 to 5 years. And the reason why I recommend every 3 to 5 years is usually one of these categories has changes. So personal, is there a new birth? Did someone pass away? Is there a divorce? Relationship changes? For example, you listed your best friend to be a decision maker 10 years ago, and now in 2022, you're no longer best friends, so you need to change that. Assets change. Did you refinance? Did you 1031? Did you have a rollover from this IRA to that IRA, for example? Again, all of your assets need to be coordinated into the trust, generally speaking. And then finally, the law changes. We had Proposition 19 severely affect property taxes last year. And so every time the law changes, that's the reason why you should be reviewing your trust and seeing what type of changes you need to make. All right, I've got 7, so I've got 2 more to go. Number 6, prepare for taxes. Capital gains taxes step up in basis, carryover basis. So I will tell you that when you set up the trust and you inherit after your parents pass away, there's this thing called step up in basis. So what does that mean? Mom and dad buy the house for 100,000 in 1960. They put it in a trust. The trust says after we pass, we give it to Junior. The house is worth 1.1 million when they pass away. The basis of 100,000 gets adjusted. Junior sells it for 1.1 million after his parents pass away. There is zero capital gains. Zero capital gains. Now, for those of you that do not want to set up a trust for whatever reason, and you say, I'm just going to put Junior on title. Forget Ed. He's just talking a lot of mumbo jumbo. I'm not going to set up a trust. I'm going to just put his name because I'm an engineer and I build bridges and I know how to rule the world. Well, if you do that, that's called carryover basis. Junior inherits the $100,000 basis. Parents pass away. Junior sells for 1.1. He will owe $1 million in capital gains because when you give it as a gift and he doesn't inherit it when you pass away, he keeps the $100,000. So big mistake. I see that happen. A lot of people who do not embrace the importance of having a Chris Ellis in their lives. That's really what people say. Well, what's the difference? It's because they did not work with Chris Ellis, hands down. Ordinary income taxes, gift taxes, estate taxes. So estate taxes, I joke, 2022 is a good year to pass away in the sense that estate taxes not a lot of people pay unless you are that person in Altadena or Pasadena that won the Powerball, right? I don't know what that is. It's like 2 billion, but cash value, it's like 1 billion. So if you pass away in 2022 and you have less than $12 million, if you're an individual, no estate taxes. So if you have more than 12 million, it's 45% thereafter. So if you set up an estate plan, we can essentially protect 12 million times 2 or $24 million. And so that's why I joke it's a good time to pass away in 2022. The reason why that's controversial is just 20 years ago, if you passed away with more than $600,000, you were paying 55% beyond 600,000. That was a bad time to pass away. Again, it's not as crazy as it is now. Homes in California were not that much, but $12 million is a lot of money, and not a lot of people have that necessarily. I do have a lot of clients that have more than that. Okay, number 7, administer the estate. So this is when you've passed away. Your son, if he is the successor trustee, has to come forward and has to do a bunch of things. There's a formality to it. So this is no longer planning, this is administering, and it's another category. Yes, there are fees, but no way is this close to what it would be if you were to go to probate. So we need to give proper notice to all of the beneficiaries as well as the heirs at law. So for those of you that are disinheriting children, right? So let's say you had children in another relationship and you have children now and then you don't want to give those other children, you can do that, no problem. But if you pass away, those children that were disinherited have the opportunity to notice. So they can see what you did and they could potentially challenge, not that they will. So I recommend that you retain an attorney, a tax advisor like a CPA, and then Chris Ellis. Marshal, collect assets, figure out liabilities, pay taxes, and then prepare and distribute assets. All right. So what I'm going to do is I'm going to transfer the microphone to Chris. He's got a couple slides, and then I promise we'll get to most of your questions. And if we can't, because again, there's 144 of you, I will give you an opportunity to contact my office if it's related to legal, and then obviously Chris will provide his information. Chris, I'm going to hand over the mic to you.
Thank you, Ed. Appreciate it. Good evening, everybody. Thank you for attending. We really appreciate the fact that we have a lot of participants on the line who are interested to figure out what's the best way to set up your estate and to protect your assets. One of the things that I really like to kind of harp on when we talk about estate planning is the planning word, the word planning. A lot of times, I've heard in the past when somebody brings up estate planning, it said, somebody will say, who died? Well, it's too late, right? The planning is over at that point. So what we need to do is be able to set this up while we're still living, because as Ed has communicated to us, this is how we retain control of our assets, even when we're no longer here or we're incapacitated. And so if you set this up properly and you've communicated all of these steps to the most important people, the successor trustees, the beneficiaries, then it should be a smoothless transition. So the role of the financial planner within protecting your estate or estate planning is, I really like to consider myself more of like a general manager that helps connect my clients or our members of the credit union to the right people to protect their assets. So as Ed has talked about, there's life insurance that could be discussed as a tool to pass on wealth. And really what we're looking at is a capital transfer of assets, right? How do we do that the most efficient way? How do we work with certain CPAs or tax preparers that can make sure that we protect assets from taxes? We don't want to have Uncle Sam get any more than they're rightfully owed. And then now we've got Uncle Gavin that we have to worry about here in the state of California to make sure that we're protecting those assets. So the role of the financial planner really is, this is somebody who you should be working with that has intimate knowledge of your assets. Where are your retirement accounts? What accounts are you looking to protect? And then how do you want those to be passed on to your family? What are other physical assets? And a lot of times we have younger people in the crowds that we're talking to. And I don't want you to only think about yourself, but if your parents are still around and still alive, you should be thinking about this as a tool that helps you protect their estate, but also it makes it so much easier to handle the process when they're no longer here and be able to distribute those assets. So it's kind of critical that you work with a financial planner early and often to make sure that you're discussing the right information that's regarding your family and your estate. And we're going to move on to the next slide. Now, Ed has already talked about this, the financial assets, and how do we set these up? And in particular, it really is when you're working with a financial advisor, and my recommendation is to talk to multiple financial advisors. I am not the end all be all for everybody. I recognize that. But if you recognize that you have the power, because most financial advisors will offer free consultations, then you could go out and get a lot of free information. Just knowing that you're the product. Financial advisors want to work with you. But here at the credit union, we like to be transparent. We want you to recognize that we have an open door policy to come in and get the information you need to help protect your finances, to protect your accounts. And then this is the beginning stage. When I start asking questions with my clients, one of the first questions I ask is, do you have a trust? And then we go back and we have that conversation again every time we talk to make sure that that trust has been updated. Do we need to make adjustments? People move out of state. They make changes to their accounts. There's many life events, and that's what we're going to talk about in this next slide, is what are the events in our lives that we need to make adjustments? Go ahead, Ed. So when you're reviewing your estate, Ed had talked about the time frame, but what are other events that could take place that you need to make adjustments? Births and deaths, marriages, divorces, moves out of states. We just talked about that. But the big one I want to talk about at the bottom here are tax law changes. So in 2018, there was the Tax Cuts and Jobs Act. Okay. Um, Now, those changes were only instituted for 7 years. So in 2025, that's going to revert back. So in 2026, we have new tax laws unless Congress chooses to extend this. Well, as Ed had talked about, it's a good year to pass away because of the estate tax, because of the, I call it a wealth transfer tax, but the beneficiary, how much you can gift, right? The gift tax that we have during our lifetime. But this is critically important to understand to make sure that you don't make any mistakes, especially as we grow our wealth. We want to make sure that you have as much information. Go ahead, Ed, and move to the next slide. And so what I want you to think about is with ordinary income, dividends, capital gains, we have a set parameter that is an adjustable scale based on what you earn, based on how much growth your portfolio grows in a given year, what your capital gains are. If you are somebody who is invested and it's money that's not protected in an IRA, not protected in a Roth IRA, but it's held in a individual account or a joint account, capital gains are still going to be distributed during this year. Your portfolio might be down 20%, but you could still get a taxable gain because the mutual fund you're in passes on capital gains. This is not specific to a trust or an estate, but I wanted to get this in because you still have time to do something called tax harvesting. Like I said, if you have an individual or joint account and your financial advisor is not talking to you about harvesting capital gains or protecting against capital gains and harvesting tax losses, this is something that you guys should be having that conversation with them, or give me a call, I'll help you out. But the big number here is the estate tax. So currently, we're talking about the estate tax being on an individual. We're going to just ballpark it. We're just going to say it's $12 million right now. That's an easy number for people to recognize. It's a pretty high number. Many of us will not attain that with all the assets that we have. But only 15 years ago, that number was under $1 million. And many of us, if you own real estate, if you have retirement accounts, if you have bank accounts, you may be over that number. What would happen if the tax laws change and the estate tax now drops from 12 million down to, say, 2.5 million, 1 million? I'm not saying it's going to happen, but these are things that could take place. And now, as if you passed away, your family is going to be responsible for paying 40% tax on any dollar that is over that threshold. And so these are things that there are unique ways to make sure that your assets are protected through trusts to protect you from estate tax. It's not a big, complicated issue now, but this is one of the reasons why the political parties are fighting so intensely right now, because we feel like maybe the Democratic Party was going to look to adjust this estate tax number and bring it back down. Under the Obama administration, it was 5.5 million. So we're talking from 12 million down to 5.5 million. That's a massive, change, and that could impact people's ability to pass on wealth without getting a major tax hit. Okay, we'll move on to the next slide. And sorry, I'm kind of rushing through this, but I want to make sure that you have as much information as possible. Hopefully, Ed and I have, covered enough information to pique your interest to get you to take action. That's what we want you to do. And I used this phrase before: capital transfer. What is the best way to pass assets on to your beneficiaries? With retirement accounts, there's a really unique one: spousal continuance. And I know Ed talked about beneficiaries listing your spouse, possibly as your beneficiary before the trust. That can be critical, especially for spousal continuance. Non-spousal continuance, you have to distribute those assets within a 10-year. That changed during the CARES Act of 2020. So there's a lot of taxes that change. Most financial advisors keep up to date on this to help make sure that you're in the know, that you have somebody who is monitoring these things to give you the financial guidance you need. And then lastly, like Ed had talked about, life insurance is a great way to not just transfer assets in a blended family, but a life insurance, those benefits come to family members tax-free. And so there are unique ways to be able to take certain assets, whether they're retirement accounts or whether they're non-qualified bank accounts, and leveraging that to be able to pass on additional wealth to family members. We'll move on it. All right. Now, what are the next steps? So consider some of the following things, of late. Have I reviewed my beneficiaries lately? One of the things that I encounter so often, and I'm at fault of this myself, and I have to go back and review. And as soon as I do, I make these adjustments. Many people don't have contingent beneficiaries on their accounts. And what I've seen, and unfortunately it's happened twice in my career at LAPFCU, and I've been there for 7 years now, we've had tragic accidents where both the spouses passed away, and they were the sole beneficiaries on their accounts. And I'm just going to give you one horror story. I know Ed talked about a few, but person comes in, his deferred compensation account was at Voya. He and his wife passed away. The wife was the only beneficiary. I was working with them, looking at building out planning, looking at rolling over their assets, pass away in a tragic accident. Because of the beneficiary and the way it's recorded, the deferred compensation plan said, well, we need to look and see who are the surviving family members. Well, this police officer's mom was still alive, and she was receiving Medi-Cal benefits. And so the Voya worked with the court and said that the beneficiary would be mom because she's still alive. And I like to say this, it's similar to, religious folks might, understand this, but it's a sign of the cross. The court is going to look up first, and then they will look down to see if there's people underneath you. So if your parents are still alive, that's who's going to get the assets. If you don't have parents alive, then it'll go down to your children. If not, then they start looking sideways at siblings and other beneficiaries. But because mom was on Medi-Cal, $395,000 went to the state of California to protect mom, and they got to keep the rest of the money when she passed away because of all the benefits she had received. So there's so many unique things out there that we've experienced. Ed and I have seen so many different things play out, and people come to us and it's too late. The court or the beneficiary designation through a retirement plan has already decided what's going to happen. So these are things that it seems very simple, but have you checked your beneficiaries? I talked about tax harvesting our losses for this year. There's been a lot of losses within accounts, and it's unfortunate, and hopefully some of that will come back. But imagine if you could take all of those losses and dollar for dollar get that back as a tax break. That's what tax harvesting is. So talk to your financial advisor, give me a call. Unfortunately, we can't do it in retirement accounts, but we can do it in other types of accounts. Does insurance help me with my goals? What do I need to protect? What do I want to pass on? And then different strategies for short-term, long-term, using a Roth IRA. That can be a great tax-free benefit for retirement and avoiding any required distribution. But most importantly, go out and seek advice. This is not just somebody who can take their assets and figure out what to do on their own without getting counsel from people who do this on a day-to-day basis. This is our livelihood. This is what's important to us. We both got into this because we had instances in our family that we realized this was a great way to be able to make a living, but go out and help people as we do that. So we're happy to help. I work out of the Academy branch for the credit union. We do have another financial advisor who's out of the Van Nuys branch, Patrick Infante. He'd be able to assist and take appointments as well. He's been in the business for 24 years, so he's got a lot of experience to be able to help guide our members as well. So with that, I'm going to pass this back over to Ed so we can then take questions. Thank you all for attending, and we'll be around to be able to answer questions for the next 10, 15 minutes.
Great. Daniel, before I go over take some questions, do you want to go over this very exciting $600 trust reimbursement, just so that we get their attentions. And I wanted to go over how they can, if I can't get all of the questions, I wanted to go over how they can contact my office as well. But I think your $600 question is most exciting.
Sure, thank you. And real quick, everybody, please take a picture of this particular screen. This will be Ed's contact information and Chris Ellis's information if you have any follow-up questions or if your question doesn't get answered tonight. But as Ed mentioned, anybody familiar with LARFPA, which is Los Angeles Retired Fire and Police Association? Most of the LAPD retirees are in this program or in this association, as well as maybe you have a spouse with the fire department that's retired. They're actually giving you guys a $600 trust reimbursement. So if you were to move forward with our services, they're going to give you a reimbursement for $600. So all you basically need to do is provide proof that you did pay for services for this particular trust, and they will reimburse you $600. Take down that information, that website, and that phone number. And once you move forward, as I said, and take on the services, you can then get $600 reimbursed.
So Daniel, I want to take this step further, and that's a $600, and then I will do another $1,000 off of my regular price for trust, which is starts at 4,850. So we'll go down to 3,850. Then they get that other $600. So they can get a basic estate plan with my office for about 3,000. Hold on, let me just make sure I don't mess up my math. 3,300 or so. Now, a couple of things. Um, I wanted to tell people that there are a lot of choices that you guys can make. There are a lot of referral services with the different institutions that support the police. I wanted to go over two important things about my office. Number one, I am the only presenter for estate planning curriculum with the LAPFCU over the last 5, 6 years. There's a lot of referrals, there's a lot of attorney for it, but for whatever reason, I'm the one that presents. So number one. Number two, I'm also the only attorney inside of the Los Angeles Police Department that gets to work exclusively with two departments. That's the Chief of Police Office in the Wellness Department. And then more importantly, I work with the Employee Assistance Unit, and I've done that for many years. My takeaway for those of you is that, thank you so much for what you do. I think it takes a particular professional to understand how important your job is. The thing is, Chris and I have done this long enough. We know what's going to happen if you don't do this. And unfortunately, we get those calls when it is too late. The employee assistance unit, I usually get a call when someone has already passed. The wellness department inside of the chief of police's office, I usually get a call when someone is about to pass away. So this is an opportunity to take advantage of this and to do it in the planning phase. That means you're healthy. That means you can think clearly, and you're going to work with people that are trusted. And so I have this QR code here on the left. Take a picture of that. You can directly schedule an appointment with my office. If you're afraid of QR codes, then you take that email, which is trust@oakcrestlaw.com. If you're afraid of email, then I have the 800 number. I have a fantastic team. Leading the initial call is a wonderful person named Rachel Zaragoza. She is waiting. She's friendly. She's nicer than me, and she will take care of you. My special fee of that discount is only for 1 month, so you need to contact her by December the 9th. Today's November the 9th. I give you 1 month, which is more than enough time to get your affairs in order. And so I wanted to go over that as well. So Daniel, can we go over some
Thanks, Ed.
questions?
Yeah, absolutely. So I do have some questions here in the chat, and I do have some questions that came in before the webinar. So we'll try to get as many as we can in these next 5 minutes or so. I don't have any family members that I trust. Who should I appoint to make financial decisions if I become sick?
I'll take that question. You know what's a very popular choice for people in that situation is to choose their accountant. And you can also choose an attorney. So our license as an accountant, an attorney, we naturally can do that job, which is the job of a fiduciary. I would say that's one option. Another affordable option is to hire a private fiduciary. If you Google California private fiduciary, there are individuals who are licensed and bonded in the state of California who do this for a living professionally. And so that is another reasonable choice. And then, of course, the big banks, any big bank has a trust department. Not to say that is a reasonable option, but they'll do that obviously for a fee. And so you've got some options there for you. Good question.
Great. A friend told me that if I get a trust, I also need a will. Do I need a will or a trust or both?
Great. I think I touched upon that a little bit, which is if you just use a will, make sure you don't have a lot of assets because if you do, it'll go to probate. Now, if you have a trust, it's called a pour over will. Now, what is a pour over will? It's just in case you forget to put something in the trust. So let's say you have 10 properties, 9 of them are titled in the name of the trust. And for whatever reason, one of them isn't and you pass away. The 9 will avoid probate. That 10th one, we will use a pour over will to go to probate court, unfortunately. The pour over will says that I have a trust, please transfer it to the trust. So it goes in ultimately. So that's the good news. The bad news is it's a will and it will go through probate.
Great, thank you. Is there different pricing when it comes to updating a trust or creating a brand new trust?
Great question. You know, I always ask and wonder if someone comes to me and they've had a trust done the last 5 to 10 years, why is it that they're not going back to the original attorney that drafted? Because in my humble opinion, that's probably going to be the most effective and reasonable. Now I get it. You guys are entranced by Chris and me, and you guys want to work with us all of a sudden. I get it. It's like going to a new doctor. I can't just assume that your previous doctor was legitimate. I can't assume that he practices like I do. So I literally have to start from beginning to end. I have to look at your toes. I have to look at your joints. I have to hear your heart. And in some instances, it's more work because I can't just assume that you have all of the things. So you know, if you come to me and you already have stuff, I will have to charge you the fee that I quoted. But in the future, if you come back and it's just a simple change, that could be a couple $100. You know, let's say you put Tommy as the successor trustee. Now you hate Tommy, you like Sally, and you want Sally to be the successor trustee. That's just a couple $100 if that's all you're changing.
Great, thank you. My parents recently passed away. They fortunately had a trust and will. Their former home is now in escrow. Will escrow distribute the funds to my siblings? If so, do I need an EIN federal number?
Yeah, so this is trust administration. So by the way, real quick, Daniel, for those of you that we can't get all of your questions because there's up now there's 138 of you. It looks like we're losing some of you, but that's okay. It's almost 7 o'clock. Please get that email or that phone number. You can send all of your questions there, and I guarantee everything, all your questions will be answered. But yeah, that's called trust administration. If that house is in the name of the trust, they will work with the trustee, and the proceeds of the sale from the escrow will be issued in the name of the trust, and then the trustee will distribute it according to the terms of the trust.
One thing I'll add on to that, Ed, as well, is there's a lot of other things that will arise in terms of the distribution of assets. When you're dealing with the successor trustee, whoever's responsible, one thing that you want to make sure is that you do leave some funds from the trust still available because there could be some taxes that have to be filed. So if everything gets distributed in 3 equal portions, you know, let's say there's 3 siblings, and then all of a sudden you're the successor trustee and you have to go file taxes and there could be taxes owed for some reason, whatever that may be. Now you have to go back to your siblings and try and get those funds back. So make sure that you're talking with somebody to help you through this, whether that's an attorney or a financial advisor, just to make sure that every little I is dotted and every T is crossed.
Great point, Chris. Thank you. Yeah, I usually distribute in 2 distributions, a larger one, but not all of it, and then a smaller one. So if there's $1 million to be distributed to 4 people, we'll distribute out, let's say, 900,000, keep 100,000 for a little bit to see what the taxes are, making sure that we get clearances, waiting for any surprises. And then at the very end, when we know that there are no more fees, then we'll distribute that final $100,000 because the worst thing that can happen is the trustee is, is rushing this and doesn't realize that there are all these surprise fees. The IRS audits and says, hey, you owe another 40,000 is already distributed. And I'll tell you, trying to collect money from people that you've already distributed is like trying to chase a cat in an alley in downtown Los Angeles. It's impossible.
All right. Thank you, Ed and Chris, and to all our viewers today. Thank you very much for joining us. As the gentleman just mentioned, please take down their contact information with any follow-up questions you may have. This presentation will be available to you. It's going to be sent to you after this webinar in the next couple of days, and will also be on the Los Angeles Police Photo Credit Union YouTube channel. So you can rewatch this. You can refer back to this if there's some information that you want to revisit. But once again, we thank you for your time, and we hope to see you on our next one. Thank you, guys.
Thank you all. Appreciate
Thank
your
you,
attention.
everyone.